On April 29, 2026, the Supreme Court issued to 6-3 ruling in Louisiana versus Callais, and that rule weakened the Voting Rights Act of 1965. This time, the focus was more on Section 2 of the Voting Rights, the part of the law that has been used to challenging vote maps. When those maps dilute the voting power of Black, Latino, Native American, and other minority voters. Before this ruling, a voting rule rights challenge could focus heavily on the effect of a map. If a district map weakened minority voting power, that effect mattered. After this ruling, the standard challengers now have to show a stronger connection to intentional discrimination, meaning lawmakers meant to discriminate. That is a much higher bar. That change had an immediate impact. States did not wait. In Louisiana, officials moved to delay a congressional primary election that was already underway, so lawmakers could redraw the district maps. This was one of the fastest and most direct reactions to the ruling. In Alabama, the state moved in a different way. Officials filed emergency motions tied to congressional maps that had previously been blocked by the courts. Instead of passing a brand new map immediately, Alabama used the ruling to try to lift legal restrictions and move forward with maps that had already been challenged. In Tennessee, lawmakers moved toward reshaping congressional districts by calling for an action during a special session. The focus centered around the Memphis-based district, which was a large Black voting population and is currently the only Democratic-held congressional seat in the Senate. In South Carolina, leaders began reviewing congressional maps and discussing possible changes following the ruling. The reporting shows that the state preparing for potential redistricting moves, though not yet finalizing a specific new map at this stage. In Florida, movement had already been underway, but the ruling gave additional momentum. State leadership signaled that they were prepared to revisit and potentially move forward with redistricting decisions tied to congressional maps. In Mississippi, lawmakers focused on judicial districts rather than congressional ones. Plans for a special session were discussed, and the existing court case involving district lines is now being affected by the new standards set by the Supreme Court. Those were the actions. Now comes what is happening in the courts. Louisiana, where the immediate lawsuit was already been filed, and Louisiana civil rights organization, including the NAACP, Legal Defense Fund, the League of Women Voters, and others filed an emergency legal challenge after the state suspended its election to redraw maps. That case is already active. In Alabama, there is confirmed court action, but it's coming from the state itself. Alabama filed emergency motions related to redistricting. That is legal action, but it's not a new lawsuit filed by civil rights groups against the state. The Supreme Court's ruling is now affecting how the case will be moved forward. In Florida, there is already an active lawsuit over redistricting, but it was filed before April 29th ruling and is not a new case created by this decision. In Tennessee, there is no confirmed post-ruling civil rights lawsuit filed as of yet. In South Carolina, there is also no confirmed post-ruling civil rights lawsuit filed as of yet.